please, my lord, my lady, my lord. I'm going to turn now, if I may, to the court's jurisdiction under Section 11 of the Contempt of Court Act. The sole issue here is whether the learned judge below was right when he held at paragraph 63, which is at page 292 of the core bundle, that if the name or information has not been withheld, has been used 62. In 292, did I say 262? Page 292, para 63, my lord.
60.
It's a very short section, it actually starts at para 60. And your lordship can see at paragraph 63 that Mr. Justice Nicklin says it's therefore an essential precondition to the making of reporting restriction orders under Section 11 prohibiting the identification of a party or witness. His name must have been withheld throughout the proceedings. If the name or information had not been withheld, a fortiori if it had been used in proceedings in open court or otherwise published by the court, e.g. in court lists, etc., there is no jurisdiction to make an order under Section 11. And that, we respectfully submit, is wrong in law. I'm going to seek to show how that is the case now, if I may. I know the court was concerned with why it is that Section 11 came into being, so I will turn to that, but I actually want to start, with, if I may, with the wording of Section 11 of the Contempt of Court Act, which is at page 15 of the Authorities Bundle 1.4. And if the court has the
Sorry, I didn't catch them.
Page 15, my lord, of the Authorities Bundle.
15.
15, 1-5. And if the court has that turned up, can I seek to emphasise the following words? In any case, where a court having power to do so allows a name or other matter to be withheld from the public in proceedings before the court, the court may give such directions prohibiting the publication of that name or matter in connection with the proceedings as appears to the court to be necessary for the purpose for which it was so withheld. In other words, it's ancillary to the withholding order, so as to effectively to give effect to the withholding order. So the language used is in any case allows a name to be withheld in proceedings before the court. And in our submission, there is no fetter based on this language on the court's power under Section 11, provided that the court makes a withholding order during proceedings. There's no wording which would suggest that withholding order has to be made at the outset of proceedings, an outcome which could obviously be easily achieved by a draftsperson, or before the name has been mentioned in open court or a court document or the like. So the wording is open. It is in no way closed or sets some sort of gateway, artificial gateway of from the outset of proceedings or such like. That's the wording. Now can I go to the purpose, and again I'm grateful to the court for giving us the Law Commission report, etc. I'm actually just going to go back to A and BBC at page 620. So that's 4.15.
Just pause there a second. Do you know how to get my screen? Sorry, do you know how to get my screen? Again, I've lost my PDFs. Sorry, technical problem.
What have you?
I've lost my PDFs and all my. They've gone small.
They've gone small. Yeah.
see, you need a master of the rules, skilled in such matters to help you through. Sorry about that, and I'm sorry about the
Not at all. It was an opportunity,
delay,
I'm sure,
but I've
my
got
Lord, welcomed
to think
to
where I need to get to. Thank you.
be of assistance. I was taking the court to A and BBC at page 620. Paragraph 58 sets out section 11. Paragraph 59 explains, this is Lord Reid explaining that it was enacted to implement a recommendation made in the Committee on Contempt of Court following the Socialist Worker case, and that, as Lord Roger explained in the New Guardian News, it doesn't itself confer any power on courts to allow a name or other matter to be withheld from the public in proceedings before the court, but it appears in circumstances where such a power has been exercised, and we see that from the language of section 11. The purpose of section 11 is to support the exercise of such a power by giving the court a statutory power to give ancillary directions prohibiting the publication in connection with the proceedings of the name or matter which has been withheld from the public in the proceedings themselves. Hence my submissions earlier that it's ancillary to and supporting the withholding order. And then Lord Reid continues, it thus resolves the doubt which had arisen following the Socialist Worker case as to the power of the court to make such ancillary orders at common law. And that is essentially shorthand of that which is set out in the Law Commission report in the additional Court of Appeal bundle at pages 1491 and following.
I mean, if you're right in your first submission, which is that there is a common law power
Yes, my Lord.
to make any order that protects the integrity of the proceedings, if I can put it that way, why was section 11 necessary?
Well, my Lord, for exactly the reasons that they've said, because it was to resolve the doubt, because Socialist Worker was somewhat uncertain. There was reference to that Butterworth case, which seemed to support the existence of a common law.
But isn't the point that if it was in doubt, passing a statutory provision doesn't resolve the doubt, it just creates a statutory provision that's clear. So when Lord Reid comes to discuss the common law in A and the BBC, you would expect him, if he was saying there's a common law power to grant a reporting restriction order, to look at the common law separately from section 11, which was the actual provision that was deployed.
My Lord,
Rather than passing it off in a breezy single sentence saying, well, this is it. In doubt, statute had to be passed to put the position beyond doubt, and then you would expect if Lord Reid is saying, well, there's already power anyway.
No doubt I could invite Lord Reid to have set out yet more guidance and knowledge in his judgment than he already did. But one, he clarified the position in Wolverhampton. Two, it's absolutely apparent, as I say, because one looks at the approach he has to the balancing exercise, which he analyses wholly through the inherent jurisdiction of the court, which he then applies equally to the reporting restriction order as he does to withholding order.
I mean, I'm assuming, for the purposes of this argument, that you're right, that there is an inherent jurisdiction to anonymise parties and to do potentially other things for the integrity of the proceedings. But we must be concerned with where the line is to be drawn. And this is fairly unhelpful, because by enacting section 11, it appears or gives support to, I think, what the judge said, which is the line is to be drawn at anonymity orders. There is an inherent jurisdiction to grant anonymity orders to protect the proceedings, but not beyond. Now, you've made, if I may say so, a compelling case this morning for some beyond, but the problem is what beyond? Because very quickly, when you go beyond anonymity, you get to what I should have pointed out before we should not be saying, contramundum orders against the world. Because any injunction that stops people doing anything with material obtained from proceedings is such an injunction. So what I'm troubled about is how this helps you rather than potentially hinders you.
Well, my Lord, can I take that in two parts? The first part is, if the court is with me, that the court can make a reporting restriction order under its inherent jurisdiction. The second part is if the court is not with me. So on the second part of it's not with me, then I rely on Section 11 of the Contempt of Court Act. I'm seeking to make my submission good, that Section 11 is engaged, provided there is a withholding order, as long as the withholding order is made during those proceedings. It doesn't have to be made at the outset of those proceedings. So that's part two. Part one, as to whether it aids or otherwise, in my respectful submission, the position is entirely neutral. The sentence given in paragraph 59 reflects that which we see in the Law Commission report, which is, well, we're not quite sure in any way, let's enact it in relation to contempt, because that was something that was apparently on the mind of the Law Commission report, and I think that I forget the name of the report which preceded it, the Green Report or some such, which they saw in a fairly specific context. When you go to page 1491, you know, they were very concerned with blackmail cases and people being protected on grounds of national security. Be that as it may, it's a provision of general application. So it came in as a result of the Phillimore recommendation and the Green paper.
So which page are you at?
I'm at page. It's for me. It's the Court of Appeal additional bundle. I don't know if you've managed to put that into one PDF for your authorities. If you have, it's simply page 1491.
Oh no, I haven't. I've just got 229 pages. Which case are we looking at?
It's the last document, which is the Law Commission consultation for 2.209 contempt of court.
1491, you say?
Well, for me, my lord, it's internally numbered page 32 after one that says page 33. So, but it's anyway. It's
got Lord Mishcon supporting the amendment, is it? The top.
Mine has actually been put together for me slightly back to front, completely back to front as I look at it. Unfortunately.
So what are you referring to?
In any event, I'm looking at what A136.
Yeah, on clause 10.
It had been marked in yellow by the court.
Yeah.
I'm going to infer, if I may, my Lord Justice Warby.
Not wrong.
And you can track through. In fact, it sort of starts at A119, and what you have there in the yellow highlighted passages is something of the genesis of Section 11. In other words, it seemed to be concerned specifically, or at least focused in on, the blackmail case, socialist worker, and concerns arising as a result of that judgment as to whether or not there was a jurisdiction of common law in circumstances where Lord Widgery had, as it would appear to be, approved that which Lord Justice Pearson had to say in a case called Butterworth, which is at page 1305, which would suggest there was jurisdiction. So down at H, in my judgment, however, such victimisation...
Sorry, I'm not with you. I haven't got Butterworth. Where's that?
It's Butterworth is referred to within the Socialist Worker. It's quoted by Lord Widgery at page 1305. That's external numbering, 1305. Internal to the judgment, it's page 648.
Yes, and you want the quote.
And what you get is Lord Widgery quoting from Lord Justice Pearson in a case called Butterworth that Lord Reid also referenced. And if you go down to between G and H, in my judgment, however, such victimisation, because it depends...
So what are you reading now? You're reading Lord Reid. I'm looking at Butterworth.
I'm looking at Socialist Worker, my lord.
Okay.
I'm all over the place. I've got Socialist Worker with different numbering from you.
I'm afraid this is because the cases were produced yesterday, and I'm not sure what has happened, but unfortunately we may have ended up with...
Could you help me with the internal pagination?
Yes, page 648 of the Socialist Worker judgment. Does the court have that?
I do.
Yeah.
And then you see there's a quote from Lord Justice Pearson. That is in Butterworth. And the quote between G and H says, in my judgment, however, does the court have that? Such victimisation, because it tends to deter persons from giving evidence as witnessed in future proceedings and giving that evidence frankly and fully and without fear of consequences, is an interference with the due administration of justice as a continuing process and does constitute contempt of court and can be dealt with summarily under the inherent jurisdiction. So that's what was said way back in the 60s. In any event, this sort of outcome of socialist worker was uncertainty. The matter was then legislated upon, but I consider, well, in my submission, the legislation is neutral as to the, exactly as my Lord Master Rolls says, if there was uncertainty, the uncertainty continues, and that's to be resolved by this court in relation to the scope of the inherent jurisdiction. So it's neutral. So that's the genesis of section 11. Can I invite you, going back now to A and BBC, so this is page 620 of the authorities bundle. Paragraph 60, this is where a submission is made on behalf of the BBC that section 11 doesn't enable an order to be made for the purposes of protecting an individual's convention rights. And you'll see Lord Reid rejects that. He says over the page, that submission is of limited significance in the present case, since, as I shall explain, one of the purposes of the order was to protect the administration of justice.
I'm sorry, you said paragraph 60 or 16?
60, my Lord, 60. Para 60, page 620, Judgment of A and BBC.
Right, okay, got
This
that.
section under section 11 of the Contempt of Court Act. We've had the what it does, why it was there, and now we're having Lord Reid say, don't construe it narrowly. So para 60 says section 11 doesn't contain any such limitation, and para 61 says it was also submitted no order could be made under section 11 unless members of the public had been present in the courtroom and had a name or other matter withheld from them. That is, however, an unduly narrow construction of the provision. And all I seek to draw from that is, please beware of making an unduly narrow construction of the provision. There's no requirement in the wording to approach it in that way. You need to approach it applying in a normal way interpretation, legislation, language in its ordinary meaning in context. And the context is, here is an ancillary power to the court's exercise of a prior power to make a withholding order. So why would you want to limit it in circumstances, and I made these submissions early doors, where a withholding order can be made at any stage and doesn't require to be made at the outset. So if you can make, as I've submitted, a withholding order at any stage of the proceedings, even though there's been publicity, the name is in open court, it's on documents and so forth, then why on earth wouldn't you be able to make an order ancillary to the order for a withholding order? It would be very narrow to construe it otherwise. Then I need us to go to the three cases that Mr. Justice Nicklin refers to. I don't need to go back to, but in that small section of his judgment I've taken you to on Contempt of Court Act, it's all by reference to some case law. So I need to just go through those cases in turn.
Sorry, can you show me them in his judgment?
Yes,
please?
well, yes. Absolutely.
Which paragraph?
It is, my Lord.
62 and 63.
Thank you. It's para 62 and 63.
Yeah.
So your Lordship can see we've got In Re Trinity, Mirror, Press Association, and Arundel Justices, and take them in order, as in chronological order. So Arundel Justices is at page 239 of the authorities bundle. That's tab 4.3. And this involved no application for a withholding order. Only an order under Section 11 of the 1981 Act. In circumstances where the defendant's name was given in public. See page 240 at H. And that led the divisional court correctly at page 241H sidebarred through to 242C to say there was no jurisdiction to make the Section 11 order because there had been no order which allows a name to be withheld. That's the language of the statute. Section 11 is triggered by a prior withholding order, and there was no prior withholding order. You see it right at the end at C on page 242. There has in fact been no direction given that those names should be withheld from the public, that is to say suppressed at the hearing in court. In my view, on that narrow point of construction, justice did not have jurisdiction in this case to make the order which they did, since the name was not withheld from the public in the court proceedings. And exactly the same applies to In Re Trinity.
Well, what did he say? He said, if the name has not been withheld, a fortiori if the name has been used in proceedings, then there is no jurisdiction to make the order. So your criticism is the words a fortiori. That, you say, is nothing, not what that case says.
That case doesn't say, I can show you that the real, it's an obiter dictum of Lord Judge that Mr. Justice Nicklin essentially relies on, and I will show you in the third case, but I've just got to labour through these cases quickly, if I may.
No, but we have to see why you're taking us to these cases, that they show he's wrong.
Yes, my lord, but can I just get through the cases, see the right answer, then we can look back at the judgment.
Okay, first association.
So the next one is In Re Trinity Mirror,
Okay.
and that starts at page 409, and you can again see at page 413 at paragraph 8 that at the hearing in the 15th December, no attempt, whether in the published court list or in the court itself, was made to withhold the defendant's name. And if you go to paragraph 19 on page 417, that is why no Section 11 order could be made, because there was no prior withholding order. Just invite you, please, to read para 19, especially the last sentence.
Yeah.
And if you then go to In Re Press Association, it starts at page 590. And what happens if you go to 592 is you can see at paragraph 5, 4 and 5, there was a trial in open court. The case was listed under the defendant's full name. He was then due for sentencing and was sentenced, and it was on his sentencing day that the defendant sought a reporting restriction order. See paragraph 6. And again, there was no prior withholding order. So it's like your direct press censorship. In Cuja, you've got ordinary open court proceedings. And if you then go to page 594, it starts at paragraph 13. And if you kindly go over the page, when you get to B to C, suffice it to say here that at the time of the making of the initial order, the defendant had been tried, convicted and sentenced in public without any order restricting publication of his identity, and there were no pending proceedings which might be prejudiced by the publication of his name, and section 4.2 was inapt. So we then come to paragraph 14. When making his ruling, the judge made no reference to Section 11 of the 1981 Act, and for completeness it's plain the section couldn't have been relied on as the foundation for the initial order. Section 11 does not arise for consideration unless the court, having the power to do so, withholds the name or other matter from the public in the proceedings before it. Now, pausing there, all that is accurate. And then it was therefore a precondition to the making of the order on the basis of Section 11 that the name of the defendant should have been withheld, and then it's put throughout the proceedings. And that, obiter dicta, with the greatest respect to Lord Judge, is just not right. There's no basis for it. It's not required in this case, and it's just not the case. You'd have to go back to the wording of the Act, and you'd have to seek to interpret it in the most restrictive way possible. And I've already taken you to A and BBC, where the withholding order was not made with the issuing of the judicial review proceedings. It was made after the issuing of the judicial review proceedings, and no point was taken.
Which case?
A and BBC, my lord.
Yeah.
That was paragraphs 12 to 13, page 608. And the Supreme Court upheld the order made at first instance under section 11 of the 1981 Act. That was dismissing the appeal at paragraph 79, page 625. That's because that obiter dicta simply has no place. There's no requirement that it be throughout proceedings. On a completely additional point, which really is, because this is a matter of proper statutory interpretation, but it would be incredibly hard to ensure that you have obtained a withholding order at the outset of proceedings. I'm not quite sure how you do it.
Well,
might not be enough.
What troubled me about it is that in Dartford, it said that the application has to be made in open court with the parties there before there is any anonymity order. And presumably, therefore, everybody has to tread on eggshells to make sure that...
I think it would have to be Part 8 proceedings before Part 7 proceedings.
Sorry?
Something like Part 8 proceedings before Part 7 proceedings. You'd have to bring prior proceedings to...
Well, it's done routinely in privacy actions in the King's Bench Division. You make an application to the master at the outset of the proceedings at the time you issue the claim, and to dispense with the requirements of the rules that require names to be put in the documents. Thereafter, you withhold the name. It's not actually particularly difficult in that context.
Well, then there must be an incredibly efficient system, and that may work for, I don't know how many privacy cases or how few privacy cases, but I cannot understand how that would cause other than the most monumental headaches of my Lord and Master of the Rolls in relation to the vast amount of other litigation which could then seek to engage this sort of approach. It also just defies all reason and logic. It means that just why? It begs the question, why? Why is it that unless there's a withholding order at the outset, I can't engage a provision of the Contempt of Court Act? Why is the court being denuded of this statutory power on such an artificial basis? It could so easily be the case that a witness materialises during proceedings.
That's a different point. I mean, what you're saying is the judge was wrong at paragraph, whatever it is, 63,
62, 63.
to have said, it is therefore an essential precondition to the
Yes.
making of reporting restriction orders under section 11 that his name must have been withheld throughout the proceedings.
Yes, my lord.
The only warrant for that is the Press Association case.
Yes, my lord.
And you say that was overturned wrong because of
Yes,
the
ma'am.
words of the statute. So that's the
That's
beginning
it.
and the end of
That's,
that point.
that's it, and I'd be delighted to move along because I have a lot to cover.
Yeah. And did the judge return to it or anything? He just assumed.
No, my lord, that's section 11.
So you say he was completely wrong on section 11. He attenuated the jurisdiction, which was perfectly obviously much wider than he said, and therefore you can succeed on that even if you succeed on nothing else.
Yes, my lord.
You get your withholding order if you're right on the facts that it's necessary, and section 11 gives you jurisdiction to get an RRO.
Yes, my lord.
Off you go.
Yes, my lord. First case, inherent jurisdiction. Second case, even if I'm wrong on that, Contempt of Court Act.
And Dartford, I mean, you will come to Dartford,
Yes,
will
my
you?
lord. Yes, my lord. Yes, my lord, I will come to Dartford. I can kind of have a look at Dartford now, just on this issue that was concerning my Lady Justice Whipple. Starts at page 626, so it's 4.16. It's right to say, and this is no doubt the fault of the advocates, that the true explanation of the twin orders being made, a withholding order and a reporting restriction order, was not brought to the court's attention, and it doesn't feature as in any particular way.
Well, it does.
But
Actually, I mean, he mentions reporting restrictions quite a lot.
exactly, my lord. So I just mean jurisdictionally, it wasn't brought to his attention, or the court's attention. Jurisdictionally, we're applying and making these two, and by the way, this is our case. That was just, this didn't happen. It's not how the court. It's not how the case proceeded in reality. However, exactly as per the observation of the Lord Master of the Rolls, there were multiple references to the court restricting publication. Paragraph 17 at page 634, paragraph 18, page 635, paragraph 34 over the page at page 641, and the
32,
35, which is right at the end when Lord Justice Morbick says, we suggest the following principles should apply. Little 3, the press will be free to report the proceedings, subject only to any order made by the judge restricting publication of the name and address of the claimant. And that's why our submission is that it was undoubtedly, and it was mirrored in the court order that they approved and made, it was undoubtedly a case of a withholding order and a reporting restriction order.
But it is quite limited. I mean, you know, I come back to my line.
Yes, my lord.
At some point, you can entirely envisage. I mean, in this case, there is a passage where I think he says that it goes beyond protecting just from the proceedings themselves, but requires there to be protection for the future. I'm sorry if I can't remember where.
Yes, my lord. Para 29, the court is between C and D on page 639. The court is concerned not so much with the direct administration of justice as with ensuring that through the offices of those who act on his or her behalf, the claimant receives proper compensation for his or her injuries. I don't know if that's what your lordship was considering.
No. He actually says to protect the
this case involved discrimination, as your lordship knows.
well, between an adult claimant and a child claimant.
Correct. Well, a protected party and a non-protected party, whether child or not. That was the nub of the reasoning, and that's at paragraph 30. In the middle at F, withholding the name of the claimant mitigates to some extent inevitable discrimination between those different classes of litigants.
Yeah, I mean, I may be misremembering, it may be another case, but my recollection is that he actually says this is about protecting against the future problems that the claimant may have.
Well, my lord, he carries on in that paragraph. In some cases, it will be possible to identify a specific risk of dissipation of the sum awarded as damages when the claimant reaches the age of majority, etc.
I mean, 34, he talks about the chilling effect of a risk of future disclosure.
Yes, my lord. The case was undoubtedly all about that issue, but it was framed by the submission they accepted was the framing of it specifically by reference to discrimination, but also as an aspect of a derogation from open justice. So the jurisdictional foundation was, I think it's fair to say, understood to be the derogation from open justice. Paragraph 5 of the judgment starts with the heading open justice and then goes through not just open justice but the derogations therefrom, including reference to A and BBC at paragraph 9.
So you say, do you, that Dartford is just an orthodox outworking of the A and BBC line of inherent jurisdiction to regulate own
My
procedure?
lady, yes, it's orthodox, but it's not exactly your paradigm in the sense that your paradigm is this case. It's a particular
Yeah.
subset because it's dealing with the court when the court is acting in a protective role, and it's dealing then specifically with the need to have attended for approval, which discriminates against protected parties, and in order to minimise that protection.
That's
that
only the
discrimination.
second part of the judgment. The first part of the judgment is broader than that.
Oh, absolutely. The setup for it is open justice and derogations from open justice. So it combines, pretty much like A and BBC did, in the sense that you don't need to go through the lens of Article 8 and Article 14. That's how the argument was presented and accepted, but you could go through the lens of describing how the administration of justice will be impacted unfairly on this category of claimant.
I mean, it might be fair to say then that this is the first case in which the real question of the line to be drawn between the inherent common law jurisdiction for the court to protect its own process in order to protect the integrity of the proceedings, to do justice, to protect the claimant or parties in a particular way for the sake of the proceedings. What happens when where the line is, where you reach the invocation of the equitable jurisdiction to get a contra mundum order, whether under the convention or under section 6, or whether under section 37, doesn't matter, but there must be a line somewhere. So you must well, it could be that there's an overlap.
Well, I think
there's an overlap.
I think in that sense it could be described as an overlap, my lord, because it's clear from, or certainly our submission is from the analysis of NBBC, and it's confirmed of Wolverhampton that is a reporting restriction order is not an equitable injunction. See the following paragraph referencing embargo judgment. It is not an equitable injunction.
So which is the paragraph about the embargoes?
It's para 35, my lord, of Wolverhampton.
35 in Wolverhampton.
Yes, my lord. It's page 1101. Para 35. At B, like reporting restrictions, such orders are not equitable injunctions. So you could have, one could imagine, a claimant who chooses within the course of proceedings to enlarge his or her pleadings to plead the tort of privacy as a domestic cause of action to seek an additional remedy within the existing proceedings. But the whole point is you don't need to. That's just intuitively that's all wrong. It's not. There's no need. There's no requirement, and we see the route through A and BBC and Wolverhampton. So you just don't go down that route.
I was thinking more about cases where, a bit more like the sort of Cuja kind of case, where you have a witness in an action who wants to have their identity safeguarded for some reason, and just where you draw the line between them saying to the judge in the course of proceedings, oh, well, you have an inherent jurisdiction, so you can help me because it's all part of the case management, and where that would then run into a contra mundum that was something different.
Yes, I mean, my lady, I should have looked it up over lunch, but somewhere in the relevant section of A and BBC, Lord Reed expressly uses the example of a witness being anonymised. It's para 35, page 613. It's also been recognised in Scotland that the qualification of the principle of open justice, which is necessary in a particular circumstances, may not be required to be as drastic as the complete exclusion of the public or the media from the proceedings, and less extreme measures such as the protection of the anonymity of a witness may sometimes suffice.
Yes, but I think my lady's concerned about something a bit different. it's perfectly obvious that in order to have a case tried properly, you may need to have a MI5 agent giving evidence behind a screen and his or her name protected. All that's completely obvious and happens routinely in some types of case. But that is fairly obviously on the proceedings side of the line. But at what point, if the witness then says, okay, I want an order now which goes beyond just anonymizing me and letting the process of the case go properly and smoothly and effectively, I want to be protected from all time from being mentioned, a bit like Abassi, where in Abassi they said, well, look, it's okay for the moment, I've got some order that's protecting the proceedings, but now I never want to be identified as the treating clinician. That obviously goes to an RRO at that point. It goes to a contramundo, not just an RRO. Well, I mean, query. It seems to me even paragraph 35 of Wolverhampton has loose language in saying reporting restrictions are not equitable injunctions. They may be, surely.
Well, I think that's a language issue, and I don't mean that cheaply when I say that. I mean a reporting restriction order in relation to court proceedings, and it's very important that it's in relation to court proceedings, is let's just call it now an RRO. That is an RRO, that is one thing. That is something the court can make, ordinarily ancillary to a withholding order, as part of its control of the conduct of proceedings. The thing that we might also want to call an RRO that is freestanding is an equitable injunction. It's a language issue, but they do the same thing.
I think that's what my lord is asking. I think that's where we're scratching away, is that there may be an overlap. It may not be this case, but there may be an overlap between them, because you might have the same person asking for an RRO in the context of proceedings, but when the proceedings end or something happens, they want a contramundum as well in addition. And so I suppose it's just figuring out where the line lies between the two.
Well, I think there is some guidance on this in Abassi, because the court was keen to emphasise the limitations of the principle of open justice to the facts of Abassi, and I think you could probably start at page 1238.
I mean, we'll go to Abassi in just a second. What did the judge say about paragraph 35 of Wolverhampton?
35 he was not taken to, 34 he was taken to.
Well, I think that's a bit harsh on the judge. I think if he was taken to 34, he would have read 35. He didn't mention it anyway.
I'm pretty sure it doesn't, my lord. He took you to the earlier passage in which he says, it's paragraph 52.
And what did he say about 34 anyway? Which is
paragraph 52, my lord. He says it's over to, essentially, I'm not going to follow it, I'm going to follow Kuja. It's page 289 to 290.
Sorry, give me the paragraph number again.
Paragraph 52, page 289 to 290, my lord.
Not part of the ratio. Oh dear.
That's code for I'm not following it, and I'm going to follow Kuja.
That's adventurous for a first instance decision.
My lord, yes.
Yeah.
So,
I mean, that's pretty explicit. He says it's obiter.
like the rest of my colleagues, everyone just says it's obiter and i.e. wrong, and I'm saying it's obiter and right.
Well,
for reasons.
The point about Wolverhampton is that it really, really, really set out to change the law. So
it's a big case, my lord. It's confirmed in Abassi as being a big case.
I mean, you know, we sent it to the Lords, to the Supreme Court, on the basis that it needed clarification. The law needed clarification, and they did what we asked. So, you know, that was.
My lord, yes, it's page 1231 of Abassi, paragraph 7. 1231, paragraph 7.
So, okay.
Para 7. This court conducted a fundamental review of the court's power to grant injunctive relief, etc. Not a whiff of a suggestion that Lord Reed wishes to back out of any part of his analysis. My lords and my lady, can I just go back?
Sorry.
Yes, my lord.
Oh, I see. So, resolution of those issues has led this court into the need to review from first principles, the Abassi court, the practice of the making and continuation of injunctions of this kind.
Yes, my lord.
And the court has looked along the arguments. And this is in particular because after the hearings in the courts below and the preparation of the written cases, there was a fundamental review of the court's power to grant.
Yes, my lord.
But the judge didn't have the benefit of that statement
No, my
as to
lord,
what
no.
they were doing in Wolverhampton.
Has not had the benefit of Abassi. I was trying to make that submission before lunch, my lord. That it's all very good and fun for me to criticise a judge. I don't mean to do it in a critical way. Just to say,
anybody's criticising.
respectfully, we say he was wrong on a number of issues, but this is.
there's no doubt this judgment is a tour de force.
Lord,
You
yes.
may be able to say it's wrong in places, but it's definitely an extremely good piece of work.
Lord, yes.
No
Sure.
doubt.
Sure, if he's tuning in, one judge will be happy to hear that from the Master Rolls.
Well, no, it's important because we criticise judges sometimes as if they have the benefit of days of legal argument, which they don't. But this has been beautifully researched and carefully done. But
Lord, yes.
But you say it's adventurous for a judge not to follow Wolverhampton, and then you point to
Well,
this paragraph.
Adventurous not to follow Exton and Dartford as well, which was binding on him and to make criticism. But my lord, we are where we are.
Well, Dartford is, it may be a more difficult case in the sense that Dartford doesn't address, as you acknowledge, it mentions reporting restrictions, but it doesn't address the jurisdiction.
It does not go through it.
So
in
he
terms,
might
my
be
lord.
quite justified in saying, look, if that didn't address it, they weren't thinking about this, so I am thinking about this. So,
Well, my lord, your lordship.
One of the points
knows-
that he makes is that the set of principles or suggestions that appears in Dartford includes listing the case under the name of the claimant as stated in the claim form.
Yes, my lord. That's
That's not a withholding order, that's an order for publicity, and then imposing an anonymity order. So that's a bit of a difficulty with the analysis that says this is an illustration of a withholding order coupled with a reporting
Lord,
restriction.
it's a little bit like your lordship's observation about how it's proceeded comfortably in privacy cases by applying to the master for anonymity at the outset, because it has proceeded effectively and cogently since 2015 in approval hearings, and the press have always respected this. I've never heard any
Yes,
suggestion.
I'm not querying the practicality. My intervention earlier was just in response to
Yes,
your
my lord.
point about practicality, when that was taking you rather out of your course when you were dealing with principles. But my point is that it has an impact, it's a bearing on how we analyse.
My lord, yes, but it's consistent with our case, which is that you obtain your withholding order at any stage, including during the course of proceedings. The fact that you've listed the case, whether it's a matter for this court, whether it says we'll change the system, because it's difficult, because you're then changing the system to making a new order in advance of consideration of whether to make the long-term order. You're making an interim order, essentially, or you're cheating. If you anonymise the list before you've obtained your withholding order, you're cheating. What does sometimes happen is parties apply in advance of the approval hearing on paper, and that has sometimes been successful. That's, again, a matter, I'm afraid, of listing, etc., and sometimes the matters sit on a desk in the corridor and they don't get resolved before the case is then listed for an approval hearing. So this is the real world we inhabit, and no one has actually complained about that issue, and it's never been taken advantage of. My lords and my lady, I was
Just
just...
wait, just before you move on, I asked you a question about 3 ago
Yes, yes, my lady.
about where the line lies.
Yes, my lady.
And I think you said that you were going to take us to a bit
I
of
was,
a
that's exactly what I wanted to do
That
now.
we're gonna go
And
now.
I didn't do this. It was all part of my master plan for my outset submissions, and I ducked taking to it on the grounds I might not
Now is your moment.
make progress. But in Abassi, we can actually start at paragraph 3, page 1230. And here Lord Reed explains, if you pick it up in the middle above C, typically the parents themselves are amongst those bound by the injunction. Such injunctions have been described as reporting restriction orders, but unlike reporting restriction orders as ordinarily understood, the effect of the injunctions is not solely or primarily, if at all, to restrict the reporting of information which has emerged in open court. Their effect is to prevent the identification of persons and institutions involved in the treatment and care of the child in question, whether or not those persons and institutions have been mentioned in court, and whether or not the court proceedings were held in public. So
Because
that
in Abassi they were not held in public.
Hastrup was not held in public.
Hastrup, okay.
Abassi was held in public.
I don't really understand that, I'm afraid. Maybe I better read it again.
Well, your Lordship can also have regard to paragraph 51 when considering para 3, page 1242. Such injunctions are wider in scope than reporting restriction orders as ordinarily understood, etc. In other words, unlike reporting restriction orders, they do not necessarily make inroads upon the open justice principle, the matter to which we will return. For all these reasons, it appears to us to be confusing and potentially misleading to describe these injunctions as reporting restriction orders. And so
what he's saying is, so this is in answer to my lady's question about
Yes,
where
madam.
the line is to be drawn. And what he's saying is, you may talk about all of these matters as reporting restriction orders, but they're not. This is a contramundum. I mean, this is where you started, really.
yes, ma'am.
This is a contramundum injunction which is brought under the equitable jurisdiction. Section 37 has all sorts of bells and whistles attached to it, but the jurisdiction exists. But it's confusing to refer to it as a nuts and bolts reporting restriction order extended from an anonymity order. So he's actually addressing the question.
He is, madam.
And as I pick up, the suggestion seems to be that if your RRO is properly characterised as an inroad on the open justice principle that would otherwise apply to the court proceedings, you're in the territory of the inherent jurisdiction. But if it's something else,
Yes,
You'd
ma'am. It's
say
what I
you-
call freestanding.
freestanding or whatever you want to call
That's
it,
my description
contramundum,
for it.
or whatever you want to call it, that comes.
It's a freestanding application. Generally speaking, you rely on your domestic cause of action. You get a couple more short references. Paragraph 115, page 1261. As under the heading
Sorry, where, which paragraph and page?
it's page 1261.
Yeah.
We're in Abassi. It's paragraph 115 under
Yes.
the heading Open Justice. As we have explained, the injunctions granted in the Abassi and Hastrup cases were not made for the purpose of restricting the reporting of proceedings in court.
Yes.
And that's why, I'll just give you the reference, but I'm going to reread Lord Hope's observation in re BBC at paragraph 13, page 439, in which he says, but the House has an inherent jurisdiction to make such orders as are necessary for the purposes of the proceedings which are before it.
So you say the line is clear enough.
Clear enough, my lord. Certainly you got the guidance from the Supreme Court. And just finally, you'll see the reference to Hastrup not engaging the principle of open justice is para 119.
Of Abassi.
Abassi, page 1262, paragraph 119. Against this background, the first point to be made is it's established by Scott and Scott that the open justice principle had no application to the Hastrup proceedings because they were in private. This is just, you know, so that you've got completeness. And it's for those reasons that in our skeleton argument we sought to suggest that the case relying on Section 6 of the Human Rights Act coupled with Section 37 of the Senior Courts Act is very much a backup case. That's our paragraphs 54 to 58, pages 44 to 45, in which may make more sense now when the court reads it again. But that's us saying our understanding is sections, because there was a time when it looked like, oh, well, you just go Section 6 and Section 37, C in re Guardian News. It's easy. And see in re S that actually went as far as saying, don't worry about inherent jurisdiction, we've now got convention rights.
But don't see tickle, because that wasn't what we said in tickle.
Tickle, my lord, is tickle anticipated Abassi in the Supreme Court, if I can put it that way. There's nothing I've seen which is inconsistent between the two.
No, well,
that analysis pertains, if I may respectfully make that submission.
Yeah, no, I mean, we've been slightly misunderstood as saying there was definitely jurisdiction under Section 6 and Section 37. What we said is if there were any jurisdiction at all, it could only be found there.
No one applied. No one. You said it in your judgment, Lord. No one raised a domestic cause of action. No one gave any evidence.
No one.
You're I'm just rehearsing.
You're going to come back. I mean, you haven't got all that much time, so you will come back to the evidence point, won't you? What the need for evidence, bearing in mind, Dov.
Yes, my lord. So that is our case on the Human Rights Act, Section 37. I don't really want to delay on that. So that we were left then with the judge relying on Section 39 of the Children and Young Persons Act 1933. That limits the jurisdiction to age 18. It doesn't apply to protected persons or adults, and that's tied in with the prior submissions you make as a reason respectfully to vitiate the judgment and start again.
But in Dartford, Lord Justice Moore-Bick said this child will become a protected person after they're 18.
You're a protected person under the age of 18 if as a matter of fact, by virtue of being a child. What he meant was he would continue to be a protected person, but on a different basis, not by virtue only of age, but virtue of mental disability.
And that doesn't invoke Section 39.
Once you're over the age of 18, you're out.
Section 39 goes. So Section 39 is your fallback position.
Oh, absolutely, my lord. Absolutely. fallback. So can I then go to ground 2 of the appeal and the approach to the balancing exercise? In our respectful submission, the guidance that the Supreme Court gives in A and BBC at paragraph 41 must pertain not just to inherent jurisdiction, but to Section 11 of the Contempt of Court Act, because that's exactly what happened in A and BBC. It was applied.
Sorry, say that again.
Yes, my lord. The guidance in paragraph 41 of A and BBC, saying there's a fact-sensitive balancing exercise to be performed in which Lord Reid identifies some, obviously not all. I mean, it's a balancing exercise of all relevant factors which may alter, but a balancing exercise, that is the right approach, whether this court is considering to make an RRO under the inherent jurisdiction or under Section 11 of the Contempt of Court Act. Section 11 doesn't say this is how you apply this power. It's silent on that, but it must be right that you apply it consistently with the guidance in paragraph 41. And we have now somewhat moved away from the in res Article 8 against Article 10. And so we move away from the actual guidance confirmed by my Lord the Master Rolls and Tickle, given by Mr. Justice Nicklin, which my Lord approved, which was that you attached very strong weight to Article 10 rights. But of course we've not moved away from the general idea that open justice is to be accorded significant weight. I mean, absolutely, we are applying to derogate from the principle of open justice. But Article 8, Article 10 does not have precedence over Article 8, and the principle of open justice must give way where the claimant establishes, applying the balancing exercise, that it's necessary for it to do so. It's as simple as that. We don't get more bogged down, and we also have to look at the substance of the role of open justice in the circumstances of the case. And we see that if you go back to paragraph 41, it's page 615.
But the restriction on open justice must be necessary in the interest of justice.
Yes, madam. And if you go back to paragraph 41 at page 615, you'll see up between G and H that Lord Reid says central to the court's evaluation will be the purpose of the open justice principle, the potential value of the information in question in advancing that purpose. In other words, it's not just a box which has already been coloured in heavily, dark, weightily. You actually have still got to analyse in a given case what it is about the purpose of the open justice principle that's relevant here, and what value not anonymising the name of the claimant adds to the principle of open justice. And here I would invite the court to caution itself against the crossover application of guidance given in the criminal law context. See in re S, see my Lord Justice Warby in the Ray case, R-Ray, R-A-I, etc., in which important guidance is given, but the role of naming a defendant in the criminal justice system is different from the role of naming a seriously injured claimant in quantum-only damages proceedings. So it's not just I've already assumed the weight stacked against me in favour of open justice. It's more, as the courts love to say, nuanced than that.
Well, in Dartford itself, they specifically said that the infringement of open justice would be limited by simply withholding the name, because you could then give all the details of the process of awarding damages and how much and everything else.
My Lord, that's exactly right. And where, and this respectfully to the advocate to the court, the advocate to court appears to suggest in her written submissions that a recent Court of Appeal case involving the Lord Justice Warby might indicate, involving court documents, might indicate that you needn't give details of the amount of the award. We say that's back to front.
That's the one thing everybody does want to know.
The amount of the award is the remedy. If you are interested, as a matter of the principle of open justice, in understanding what the courts are doing, you want to know what is the cause of action and what is the remedy. The remedy may be nothing, nil, you lose. That's the remedy, lost. It may be an award of damages, in which case how much. So those things are very important. And there is no doubt that the application for anonymity involves a much less serious derogation from the principle of open justice than simply conducting the case in private. And you see reference to that, for instance, in Socialist Worker, page 1309b, per Lord Widgery. So this is a case, see the observation just now of my Lord the Master of the Rolls, in which the claimant is proposing that in the face of the anonymity order, nevertheless, details of the claimant's injuries, the claimant's care and treatment will be provided. It's just they won't be linked to the claimant. That's the point. It's not that you shouldn't have details that this is a claim being brought in relation to this issue. Now these are the heads of loss. This is an amount that will or will not be awarded for a hydrotherapy pool, for 2-to-1 waking night care, and so on and so forth. All those details are part of the court's function, which is now setting out for the public at large and the press in particular. That's fine. It's just the association of that with this particular claimant that is in issue.
I mean, do you say that there could ever be a point at which there was so much information in the public domain about a case that it would be inappropriate to grant an anonymity and associated RO?
I think the court has to be incredibly careful before going that way, because if anything, now this may seem a bit much, but if anything, prior publicity is all the more reason for the anonymity order, because you're incredibly careful before saying, oh well, let alone treating it as I said before, as some sort of binary issue. This name has been publicised. We start at the lowest level, sort of it's on the Westlaw docket, which we've all now discovered, which we didn't know about before. But it's on the Westlaw docket, or it's on the name of the pleadings and so forth, and maybe someone's applied under CPR 5.4c for sight of a statement of claim and so forth. That's your really minimal level, and it goes through a range. But the point is, just because a name has reached the public consciousness in some way does not mean that the court should wash its hands of the issue. That is a position which has been made very clear. Let me just go to this, if I may. So, can I develop these submissions by first of all making this point? The claimant himself did not control the level of publicity which has occurred to date. He's a child, a protected party, and decisions to seek publicity were not made by him. The second point is a general one, that a case can receive publicity without any involvement or encouragement by the claimant's family, the claimant's solicitors. You can have a pile-up, and I think we've had various pile-ups recently in the news, and they get publicity, and perhaps someone has gone out and managed to work out who's who in the bus or a train and so forth. And possibly none of it has been encouraged by the injured person. And the third point is that the publicity that the claimant's mother sought was for good reason. It was to obtain initially fundraising from her community, and secondly to raise an issue of public importance, namely concerns regarding the quality of services provided by her local maternity services. So that understanding that as the backdrop or context, it would be particularly odd and unfair if earlier publicity were to operate against a child claimant. What that would be doing would be to discourage protected parties or their families from engaging with the press, which I work on the basis is in this sense a good thing, because subsequently they will not be able to obtain anonymity orders. We also have Lord Mance in PJS, and your Lordship recall that's one of the cases which involved Venables-like application C. Abassi when it was referring to Cuja. And if I can just give you this at 714. So this is an interim injunction for a celebrity in circumstances where the name of the celebrity is accessible on the internet. And the question for the Supreme Court is, should we nevertheless make the interim injunction? And Lord Mance is fairly emphatic in the highlighted passages, including at paragraph 1, if the court has it, at E, on the basis of the case law, the fact that there have been significant internet and social media coverage and limited hard copy publication outside a jurisdiction which already invades the privacy of the claimant and his family is not decisive. Newsgroup newspapers' purpose in applying to set a right into injunction is to add extensively and in a qualitatively different medium to such invasions. And then Lord Mance highlights para 3 that he's well aware of the lesson which King Canute gave to his courtiers. It's no good just throwing your hands in the air and saying the tide's going to come in and I can't stop it. The court has a role to play, And here what we have is, yes, there are articles out there in relation to this highly vulnerable child, but that is of a different order of magnitude of risk to that which was being proposed by a media outlet leading to this application to the court, which is that there be further publicity in relation to the case. Now it is a quantum-only case and liable to be settled shortly. Because that is now going to up the ante and link this claimant to the recovery of substantial damages. And that is the risk that this court, in our respectful submission, should be very focused on protecting against. Risk is what this is about. Is A and BBC is still only a case of risk. There was no certainty that A would go back to A's homeland and would suffer in some way. That was a risk assessment that publicity in relation to deportation in the United Kingdom would give rise to difficulties in his homeland. That's not a guarantee at all. That's a risk assessment. So there's no difficulty with this court intervening, say, oh, A and BBC is a paradigm case, easy case to decide. Well, this case I don't need to fit myself into the mould of A and BBC. This is its own case. But I just say that A and BBC was a risk assessment case in which the court was particularly concerned with the impact of making court orders that then aren't followed through. And this case, I made that submission just before lunchtime, is in just the same order. So that was A and BBC. The case of R and C is at page 642. R bracket C against Secretary of State for Justice. This involved a judicial review challenge to the Secretary of State's refusal to grant a patient subject to a restriction order unconditional leave. See at paragraph 8 at pages 646 to 647. And at first instance, Mr. Justice Cranston, see paragraph 10 at page 647, refused the anonymity order on the basis, see para 10, previous proceedings about this claimant are publicly available and I cannot see the justification for anonymity. And Lady Hale went on to ensure that there was anonymity in this case. And out of interest, the court will see that she did so expressly seeking to apply CPR 39.24. See, first of all, I referenced to it at paragraph 15, page 648, and then see conclusion in principle, paragraph 36 at page 655. And although I couldn't find within the judgment something saying a reporting restriction order has been sought, it stands to reason it must have been a withholding order coupled with a reporting restriction order, normally known simply as an anonymity order. Because a withholding order without that is not effective in circumstances where the applicant's name is in the public forum anyway, see paragraph 10. So I infer from that, but I have to infer, from that that was Lady Hale having no difficulty in applying CPR 39.24 in making both a withholding order and a reporting restriction order. And so against that, we say that respectfully the learned judge erred when at paragraph 132 at page 310 this is one of a number of sections, to be honest, but he says the amount of material, para 132 in the middle, the amount of material about the claimant and the claimant is available in the public domain, most of it placed there voluntarily as a result of interviews by the claimant's side as a result of conduct of the proceedings without anonymity order having been granted, makes any effort to anonymise them at this stage both unjustifiable and futile. Respectfully say that is literally the wrong way round. That is the Canute approach, or the approach that Canute didn't adopt because he understood what was going to happen. But it's just to say I can't do anything about it. You can do something about it. This is a court exercising its judicial function to mitigate within the confines of the necessity to do so and to the least extent derogating from the principle of open justice possible, but to mitigate against the risks that this claimant otherwise faces and therefore of the court order being frustrated.
It also just struck me reading that there might be a point to be made about the difference between the information that was already in the public domain and that which was going to come out in the course of a trial, because I confess I haven't read the articles, but I doubt they go blow by blow through what happened on that terrible story that you see in the particulars of claim. And it certainly doesn't include any reference to the figure, because that wouldn't have been known. So this is fresh information.
It's fresh information, my lady. It's right. There's one reference to my instructing solicitor saying that claimants in relation to the maternity hospitals could be recovering tens of millions or something like that. That's a general statement, not about the case at all. So that's Lord Mant saying this is qualitatively different. Don't throw your hands in the air and say I can't do anything about it. You can. Another issue which the court asked for our submissions on related to what's the significance of names as an ingredient of the open justice principle. And undoubtedly, we don't seek to say otherwise. It's better for the press to have a name to attach to, and even better a photograph.
It's Lord Roger, I can't remember the case.
My lord, it's in Guardian News. Absolutely. It's I think it's paragraph 63 at page 485.
What's in a name? A lot.
Yes, yes. But you here, what I would like to emphasise is it's highly relevant to take into account the approach of the two media organisations who'd already provided reports. And I won't reference the name of the first one or the second one, but in any event, I'll give you the references from it. It's in supplemental bundle 213 and 214, pages 213 and pages 214. The key points that they made were as follows. The public interest attaches to the quality of the midwifery services at a certain hospital. There's also a public interest in knowing how much any award of damages may be and the reasons for making an award. And all of this can be achieved with an anonymity order. In other words, they were not objecting to an anonymity order. Not least one which anonymises the claimant's name going forwards in relation to quantum, but not backwards in relation to the historical issue of midwifery services or requiring them to play with their electronic footprint. So respectfully, again, we do take issue and say this is a matter of appeal and law. The learned judge was wrong when at paragraph 131, page 310, he said that the position adopted by the media was neutral. That's not neutral. That is a clear steer from the media that the effect of the proposed order will not be to stifle their ability to report on matters of public interest. And the claimant would ask this court to take into account a submission I've touched upon earlier, that since 2015, practice, and essentially the invariable practice, I've never heard of an anonymity order not being granted. I'm not saying I've heard of every case, I'm just saying it's not come to my attention at all, that the names of all claimants at approval hearings have been anonymised, and at no stage has the press sought to challenge that position. This case would have been their opportunity to do so. I know there was the email yesterday from the BBC, slightly odd because the issues that the court raised were issues which have been fully in this appeal from the outset. So nothing's changed. The articulation that you want focus on certain issues, but those issues are writ large in Mr. Nicklin's judgment. So obviously I wait to see what my learned friend Mr. Brown says, but there's been no indication in their written submissions that they are other than content with the ordinary practice that the name is approved for is anonymised for an approval hearing. That's not neutral. That's 10 years of a practice taking place. That this is my Lord Master Roll says, a big case or important case, and this was the opportunity for them to be upset and say, hold on, if they chose to, and they didn't.
Can I just go back to what Mr. Justice Nicklin said? I wondered if in his mind was the concern that we very often have in criminal cases, where you have anonymity orders, usually by statute, and that's jigsaw identification, so you have to be really careful about details. And as I understand it, on what you're proposing, if you were to get the order that you wanted, it feels like you're saying you could live with jigsaw identification.
My lady, that is exactly the position. We are trying to obtain an order which derogates to the least extent necessary.
So you're not, because it may be that what Mr. Justin Nicklin, rightly or wrongly, thought was happening is that he was trying to put the genie back in the bottle or whatever, and stop any ability of anybody to put two and two together and work out the identity of this claimant. But I don't think you're going that far, are you? You're saying that if somebody really wanted to rummage around on the internet, they probably could put two and two together.
We may not be able to stop them. It's this mitigation of risk. You are substantially reducing the risk, and that is what counts. I think that I thought yes. So that is exactly the position. I was actually just going to. I was looking at PQ against Royal Free, the Mr. Justice Martin Spencer judgment. I may go back to that when I make a separate point, and then pick up on that jigsaw identification again. Your ladyship has actually made the point that I won't be able to add to.
But that's right, is it?
That is absolutely our case.
You live with somebody.
We would tolerate that because this is the real world, and this is minimum invasion or derogation. And we fully expect that in the real world circumstances that will provide adequate protection, because we know that the main press players will respect that order.
So paragraph 3 of your draft order, you would, if necessary, tailor that to permit continued publication of what's gone before. We touched on this earlier.
Yes, well,
this is page 56
we
to
certainly
57.
Tended to...
I don't want to draw you into the details.
Yes.
Just into
yes,
just
my Lord.
really addressing the principle.
From the date of this order, coupled with paragraph 5.
Well, the detail in practice, sometimes when you say any identifying details, that creates the problem, because there'll be bits that can be reported that aren't the name or address that are part of the proceedings, which will easily be linked to earlier reports, let's say things that the claimant's mother has said, which exist out there. But you would accept there may be cases, without going into the details of this one, where it's not really reasonable or practicable to impose those hindsight restrictions on continued publication of what has already become public.
Yes, well, that's why...
In other words, the public domain proviso says this doesn't affect anything that's already in the public domain.
Yes, my Lord. Lord Reid says it's a fact sensitive. I know we sort of use these expressions, they get trotted out. We don't reflect on what we're actually saying sometimes, but it means what it says. It means you have to look at this case. And then
there may be cases where the court is being asked to do more. I mean, there's no one size fits all. But in this case, you're not asking us to do any more than just say, don't make it any worse.
We've elected not to press retrospective. We think prospective will do the job.
But I'm just wondering, sorry to press on.
Yes, my Lord.
At the time you were before the judge, and was he not dealing with an application which was?
Well, I wasn't before the judge, but
that may
at the
explain.
time the application was made.
Maybe a material difference between the cases.
It may be, my Lord. It's part and parcel of how unfair it would be to launch into sort of over-criticism in relation to something that's simply proceeded. We say once it's set off down the wrong track, with endless reference to exceptionality and so forth, then it's rather coloured the learned judge's assessment of the merits of the application. In relation, I think my Lord, the Master Rolls is asking about the quality of the evidence. In relation to the quality of the evidence, first of all, could I reference the Exon Dartford case at paragraphs 28 and 30, pages 638 and 639. This is paragraph 28 down at H. One limb, if you like, of our case relates to privacy itself. It's not the only limb, as you know from the submissions I've made, but more on the invasion of the family's privacy, which a reportedly approval would involve if the claimant's identity became public. It would be difficult for a claimant's parents or litigation friend to put into words the effect that an invasion of privacy is likely to have on the family's life, and whatever fears are expressed may not in the end be realised. For that reason, statements which attempt to deal with such matters may well appear to be formulaic. We do not think that the importance of maintaining the family's privacy should be underestimated as a result. And then para 30, you see at E, sets out, in many if not all of cases, the court will need to consider evidence of a highly personal nature relating to the claimant's injuries, current medical condition, future care needs and matters of a similar nature. In relation to the quality of the evidence, the claimant truly is between a rock and a hard place. Because if the claimant applies, take it all the way to the position adopted by the learned judge below in relation to engaging Section 11 of the Contempt of Court Act to, at the very outset of your proceedings, nothing started. Maybe the case has got some history before, but it may have no history before. It just depends on the circumstance of when it's been issued and what's happened before. And so there may be no particular evidence. You don't even know if you're going to win your liability trial. And you can take that all the way through to, have you got to wait until something bad really happens? Which doesn't make any sense. The answer must be no, you don't have to wait that far. So it's incredibly difficult for a claimant to know when to apply. What this claimant did was apply when the press very fairly notified the claimant's mother of their intention to write a further article. So that then, on any view, the risk of publicity was absolutely real at a time when we were at the sharp end of the business, namely approaching the quantum trial, which is actually in December of this year. And the idea that this claimant is not at significant risk of exploitation is not one, respectively, which we would say is other than, it's obvious. Yet it's a position in which the learned judge described, quote unquote, the risk of exploitation as somewhere between very remote and non-existent. Paragraph 129 at page 110 of the core bundle. So that again is, we respectfully submit, an error of law. It's just a complete misunderstanding of the reality for a child who's going to be in receipt of such substantial funds.
Can you explain that to us? Because
yes, my lord.
This isn't my wasn't my field of practice. The evidence before the judge was, I think it's fair to say, exiguous on this. It was really nothing more than assertion, really very much along the lines that you've given us now. Why is it self-evident that someone who's going to receive a large sum of money is vulnerable to exploitation, given all the measures that can be taken and often are taken to safeguard
my lord,
those funds and to
the measures
guard against it?
Measures taken to safeguard, the principal measure taken to safeguard is having a deputy.
Yeah.
A deputy can be a family member. Deputies do not have to be professionals. Deputies and professionals have got to apply some degree of light touch management in relation to proceedings because they charge out of the claimant's damages for their services. So if they are heavily involved on a more micro basis, then they will be very expensive indeed. The official solicitor, and I will leave the official solicitor's counsel to develop these submissions if I may, has set out with some care in her second witness statement the reality on the ground, if I can.
I wanted to ask you if you agreed with the content of that witness statement.
My lady, yes. I don't wish to, as you've seen from the submissions I make, I don't wish to say we are akin to the Court of Protection proceedings and such like, and there are fixed new rules and so forth and transparency orders. That's not my case.
Not the legal submission, but the witness statement.
But the witness statement
was very
powerful,
informative.
powerful and informative, my lady. And so, my lord, yes, I would refer you to that. We shouldn't personalise matters, but if you just imagine having a child who is profoundly disabled with cerebral palsy, profoundly disabled, you give them, not particularly keen to mention in open court the sorts of sums of money involved, but many, many millions of pounds in an environment and a community that is not used necessarily to home ownership. You have carers come into your home all the time. You have therapists come into your home all the time. This is human nature, sad as it may be, but this court can take judicial notice and of course has experience of all of these matters. The realities, my lord. The realities of human conduct and how it ends up passing through the legal system and what it is that people do. How is that not obviously a real significant risk of exploitation?
Can you help us? I mean, maybe the official solicitor is better to do this, but with examples of commonly occurring bad conduct that sometimes one comes across in these cases.
My lord, as a barrister, I wave goodbye to the case when it's settled, but in advance of settlement, it's not unusual, and I've just settled a different cerebral palsy case in which mother and father are at war, and then you have family issues. Family families, as we know, come in many shapes and sizes, and money plays. It just has its own divisive role. One knows this from simply coming to an age when parents may be passing, and the effect of estates arising. One sees human nature in its naked form. That is the effect of money. It has a naturally corrupting influence. That's just within a family. That's before you get the stranger, or you get. And I don't wish to make submissions in open court unfairly towards carers as a caring group of people in very difficult circumstances. So it's incredibly careful, but it's not difficult to understand how people can engage with the claimant from many different lines with many different ambitions. And that is why, even within the family, I will always say, it's up to you. If I have, for instance, an adult, brain-injured, incapacitous claimant with a litigation friend, who can be the mother, the husband, the wife, the partner, whoever it is, I say it's up to you if you want to tell your extended family, but I completely recommend you don't, under any circumstances, but it's up to you. I don't control you. I'm just going to give you some advice. Don't tell anyone how much you've recovered. My lord, I was then going to turn to the relevance of the need for the approval following settlement. And I start by making this submission. The case is overridingly likely to settle. And it's not just a question of the court trusting me on this. We see from the incredibly few reported quantum cases, I mean, the last big one was CCC from Mr. Justice Ritchie, and yet we are busy settling these cases on an almost daily basis, and I've settled one Millennium from Mr. Hire not that long ago. I mean, it's something we do a lot of. Almost all of these cases settle quantum only, very high value, the highest value claims very rarely go to court. So the court can take judicial notice, and you can probably look at the number of approval hearings that you have for these cases and compare them to the number of trials. And this case is overridingly likely to settle. That means that it's going to go to an approval hearing. If this court accepts, A, it's bound by, in any event, accepts the force of the Ex and Dartford judgment, then this court, I said at the outset, we're not engaged in the parens patriae jurisdiction, but it is relevant that this case is likely to settle, and that if it settles, the court will be engaged in its protective role. And what we do not want to happen, shortly before the case should settle, is for there to be publicity in relation to the case, which thereby removes the benefit of the approval of the anonymity hearing we would otherwise obtain.
The jurisdiction to approve the settlement is accepted to be an exercise of the court's parens patriae.
I'm not sure, my lord, I would put it that far. What I would say is exactly the way in which it's been put by Lord Justice Moore-Bick, page 639, paragraph 29. At C, the function which the court discharges at an approval hearing is essentially one of a protective nature, as it was when it exercised the function of parens patriae on behalf of the Crown in relation to wards of court and lunatics. I don't think it's necessarily the parens patriae jurisdiction. I think it is jurisdiction akin to that, of a protective nature, exactly as Lord Justice Moore-Bick has identified.
Statute, or rather the rules, have replaced in a statutory form something that was previously, first of all, operated by the ecclesiastical courts and later by the common law courts.
We're very, very grateful, my lord, for that.
Well, don't take me as an expert on any of this, Mr. Ware, but that's what I seem to have read, and you agree.
My lord, yes. The parens patriae jurisdiction, I never gave it a reference, page 1244 of Abassi, paragraph 56, is where it's set out that it's an equitable jurisdiction inherent in the High Court. And there is also a passage which is worth noting. When I started my submissions, I said we're engaged in ordinary adversarial litigation, and one of the questions was, well, can we engage the parens patriae jurisdiction? At page 1238, paragraph 38.
Sorry, 1238.
1238, my lord, paragraph 38. You'll see that Lord Reed explains it's important to start the analysis of injunctions of the present kind by focusing upon the type of proceedings in which these orders come to be made. In proceedings of this kind, this is the best interest application, the High Court is exercising its inherent jurisdiction as parens patriae, and then drop down to H. It is not acting simply as an adjudicator between the competing rights and obligations of the parties in an essentially adversarial contest between them. And over the page, para 39, there is therefore not a claimant and one or more defendants in the usual sense, each pursuing their own interests in competition with each other. So although he goes on to say, even in parens patriae, this is para 40, you can have a scrap, because obviously you get the mother of all scraps in these best interest hearings between the one or more parents and the hospital, it is qualitatively different. And so we are not engaged in a parens patriae jurisdiction. We are ordinary adversarial litigation in the quantum-only personal injury context. But the submission I'm seeking to make is that this would be a classic case of the court in administration of justice not operating in a way to enable it to make the right order later. In other words, frustrating the administration of justice by not being able to make as effective an order for anonymity as and when the case then comes for approval. And that's an issue, I can now go to the PQ case, that Mr. Justice Martin Spencer fully understood in PQ. It's at 851.
What's the tab number, if you have that, please?
Yes, my lady, it's 4.24. 4.24. This was an application for anonymity in advance of a liability trial. So before the claimant knows whether they're going to win. And it starts at page 850. Mr. Justice Martin Spencer recognises the ratio of X and Dartford, and then the key paragraphs are 8 and 9. May I invite you please to read paragraphs 8 and 9.
Yeah.
That was Mr. Justice Martin Spencer grappling with that very issue, and he considered it appropriate to make an anonymity order in that case. Because you would not want to frustrate the court's ability to protect the claimant come approval hearing. And that's why we say that it's not protective jurisdiction, but the consequent protective jurisdiction role of the court is relevant to this assessment. My Lord, contrary to expectation, I have actually finished 15 minutes early, which does also give my learning friend Mr. Brown his opportunity to make his submissions as he's keen to today, I believe, but obviously it's a matter entirely for the court how it chooses to proceed. Can
Right. Well, Mr. Brown, you're in difficulties tomorrow, are you?
My Lord, I can be here tomorrow if that would assist as well.
Right. But does anybody else object if Mr. Brown goes now?
No, my suggestion in discussion at the bar was that it made sense if he went now, in fact.
Good.
Because,
There you go. Mr. Brown. Thank you very much, Mr. Ware. Very helpful submissions, and sorry if we made it sound as if we were, what should we say, not listening at the beginning.
Not at all.
We always were listening, by the way. Just inquiring. Mr. Brown, where are your submissions in the bundle?
My Lord, they are a core bundle.
10.
I believe it's tab
10.
10.
I haven't got a tab 10. Is it 1.10? Yeah, got it.
That's right.
Yeah.
Page 77, my Lord.
Yeah, I got it. Thank you.
My Lords and Lady, before I begin, can I just ask what time remains available to me this afternoon? We've covered a lot of ground over the past day, and there's 15 minutes left until 4 o'clock, so I'd just like an indication as to how rapidly I should try.
Well, I
and
mean,
get
you
through
do
my
your
submissions.
best to finish by 4:15 if you can.
I will do my very best, and that should be possible. I'm very grateful for that indication. My Lords and Lady, I appear on behalf of the BBC. The BBC is one of two interested parties on this appeal. I just want to make two overriding points from the offset. First point is that, as the court is aware, the BBC has adopted a neutral position on this appeal and on the specific application that's been brought by the appellant. That's point number one. And point number two is that my learned friend made reference earlier on to a media organisation who is proposing further publicity in respect of these matters, and said that the appellant had made the application in question in response to that indication. That media party was not the BBC, and it's important that I say that here. My Lords, my Lady, yesterday the court indicated that it would assist to hear submissions on 4 issues. How I propose to assist is to try and take the issues in sequence, identifying some points of emphasis from my written submissions of last month, and picking up on some of the matters which appear in the materials which were circulated yesterday. I've done my best to detect what it is I think the court is interested in on the basis of those materials, so I'll try and incorporate that into my submissions. It's also very important, I think, that as part of that exercise, I address A and BBC head on, because there was such emphasis placed on it by my learned friend. He described it as a good line, I think. So I'll take 4 or 5 minutes or so to say what we say about that, if that would be helpful.
You can do that at the outset.
My Lord, I will. In that case, could I just ask the court to turn up my written submissions? Paragraph 10, so this is page 81 of the core bundle. And the court will see that I've responded to various of the points made by my learned friend and his junior on these matters, and expressly in relation to A and BBC. What I said, I'll wait until everyone has a copy in front of them. It's important that I say that what I said in relation to A, paragraph 10A for alpha, Roman numeral 1 of my written representations, was, on reflection, a little bit bald, where I say the BBC understands from the paragraphs I've indicated of A that the Supreme Court was in that case concerned only with the court's power to make a withholding order, not a reporting restriction order. What I should have said, of course, was that in the relevant sections relied upon by the appellant, because that's the key point that I want to address you on now.
Sorry, what you should have said is what?
Is that the Supreme Court was, in the relevant sections, relied upon by the appellant, concerned only with the court's power to make a withholding order. I've made a generalised statement about what it is that the court was doing in those circumstances, but I just want to nuance a bit, and I'll explain why I say that now, my lord.
Yes.
My lord, so that I can do that, could I just ask the court to turn up A and BBC? It's in the primary authorities bundle, 4.15. Paragraph 598. And in sum, what we say, my lords, my lady, is that this authority is not authority for the principle that the common law grants the court a power to make reporting restriction orders. I'm going to explain why I say that. Could I ask the court to start at the beginning of the judgment, page 605, paragraph 2. This is the most important paragraph for my purposes. So if I can ask the court to remember this and nothing else.
Paragraph 2.
Paragraph 2, my lord.
Yes.
The appeal is brought by the BBC in order to challenge an order made by the Court of Session in proceedings for judicial review of a decision of the upper tribunal. In its order, the court permitted the applicant for judicial review to amend his application by deleting his name and address and substituting letters of the alphabet. This is crucial, my lord, in the exercise, my lady, or, as the BBC argues, purported exercise of a common law power. That's the key issue here. The court then goes on to say, the court also gave directions under Section 11 of the Contempt of Court Act 1981, prohibiting the publication of his name or other identifying details and directing that no picture of him should be published or broadcast. Now, having identified that there is a dispute around whether or not the power in question was exercised or purportedly exercised, the judgment then goes on to say at 3.1, the appeal raises the following questions: whether the court possesses any power at common law to protect the anonymity of a party to proceedings before it, where the convention rights are set out in Schedule 1 are engaged. And the court can see what the BBC said about that at 3.1. And the further issues which were raised on the appeal are at 3.2 and 3.3, and the court will note that 3.3 is expressly related to Section 12 of the Human Rights Act. Now, I'm just going to take the court through the key sections of the judgment. I know the court will look at this in total after this hearing. If the court would please then turn to paragraph 21 on page 609. My learned friend drew the court's attention to this earlier, rightly.
Well, I mean, we need to look, do we not, at 13.
Yes.
Lord Boyd allowed the petition. He made an order under Section 11 prohibiting publication.
Yes.
And you applied at 17 for it to be recalled. That was the Section 11 order, right?
Yes.
And Lord Glennie accepted it was necessary to allow the names to be withheld.
Yes.
And to make the Section 11 order. And then you appealed.
Yes.
21?
Yes?
Yeah.
Yes. My learned friend rightly said that the present appeal is brought against that decision. So that's right. We don't resile from that. Now, if I can ask the court to follow the general structure of the judgment. So having set out what the issues are and what it is that was on appeal here, the court then looks at the general principle of open justice. That's page 610, paragraph 23. General principle of our constitutional law that justice is administered by the courts in public and is therefore open to public scrutiny. Page 610, paragraph 27. We have exceptions to the principle of open justice, the discussion about those. Since the principle of open justice is a constitutional principle to be found in the common law, it follows that it is for the courts to determine its ambit and its requirements, subject to any statutory provision. And then moving forward, paragraph 32 on page 612. Now, this is an important paragraph. It has also been recognised in the English case law consistently with North's requirement of the degree of privacy being kept to a minimum, that where the interests of justice require some qualification of the principle of open justice, it may not be necessary to exclude the public or the press from the hearing. It may suffice that particular information is withheld. It goes on to say, I'll ask the court to read the rest. In the last 4 lines, namely that the witness should give evidence in public but should be permitted to withhold his name from the public and the press. Agreed that the court could do so in the exercise of its inherent jurisdiction to control its own procedure. Then again, page 613, paragraph 36. The court will see the emphasis that is being placed here on the power to withhold, in keeping with the exercise or purported exercise of a common law power to do so, as identified in paragraph 2 at the very beginning of the judgment. Paragraph 36, line 4, it therefore had the inherent power, in his opinion, to withhold the identity of a party where, regardless of the outcome of the case, the disclosure of that party's identity would constitute an injustice to him. And page 614, paragraph 38. As I've explained, it's long been recognised that the courts have the power to permit the identity of a party or a witness to be withheld from public disclosure where that is necessary in the interests of justice. And then we move at page 615 to paragraph 42 in the section on convention rights. Separate discussion about that. Then the separate discussion on page 619 about the relationship between the convention and domestic law, paragraph 55 onwards. And then finally, and importantly, at page 620, paragraph 58, brand new section about section 11 of the Contempt of Court Act 1981. In other words, the preceding section is focused, or at least we read it as being focused, on the power of the court at common law to make a withholding order. And therefore the remarks that are made in that respect refer to that power, not to any power to make a reporting restriction order. Now at page 620, paragraph 60, the court can see what the BBC submitted in respect to section 11. It was about the basis on which an order could be made. And the argument was that it could only be made in order to protect the public interest in the administration of justice. The court can see how the court managed that at paragraph 60. And then at paragraph 61, further submissions from the BBC about section 11 again. This was identified earlier on by my learned friend as having been characterised by the court as being an unduly narrow construction of the provision. But that's a separate point. And then finally, and this is the last part of the judgment I'd like to bring the court to, paragraph 75, please, on page 624. Court, having considered all of these issues, says, in these circumstances, it was plainly necessary in the interests of justice and in order to protect the safety of a party to the proceedings to depart from the general principle of open justice to the extent involved in the making of the orders made by Lord Boyd. it follows that, subject to any issue arising under the Convention, the order allowing A to withhold his identity in the proceedings was in accordance with the common law, so the withholding order, and the Section 11 order was made in accordance with the power conferred by that provision. So the court sees the demarcation between those two issues in that paragraph. And I hope I've illustrated how the court has got there, albeit I've taken the court through the judgment fairly quickly.
Could you help us with your analysis of paragraph 55, since that has played such a large part
My lady,
in the claimant's submissions, in the appellant's submissions? So that's in the part that's dealing with what we call, I think, the common law, before we get to Contempt of Court Act. So in the bit that you say is all to do with withholding orders, I think, is that right?
yes.
So are we to read paragraph 55 as confined to withholding orders under the common law? Because those last 5-6 lines certainly have been understood by the appellant to go a bit broader than that.
Well, my lady, that may well be so, but there's a question around whether or not that's actually a sufficient basis for the appellant to convince your ladyship and my lords that the discussion here is such as to establish a common law power to make a withholding order and a reporting restriction order. Right. And that's a leap which, in my respectful submission, those lines don't permit the court to make.
These are all about restraining publicity orders,
yes,
and publication. So it's all in the realm of what we have loosely called reporting restrictions.
Loosely called reporting restrictions, yes.
But I think, I just want to understand your submission here. You
yes.
say that this, I mean, do we understand it as only actually talking about withholding orders, or
well,
how do we understand those lines?
The section of the judgment that I'm most focused on, my lady, is the section running up to this section, so running up to 55, so up until that point, because it's the section which contains the various points around the power that the court has at common law to regulate its own proceedings in the various terminology that's used by the court. I brought the court through that section of the judgment. Our reading of the judgment is that what it is that the court is looking at there is the common law power to make a withholding order, not a reporting restriction order. And therefore it's on that basis that we say that the conclusions that the court's been invited to draw by the appellant should not be accepted in respect to reporting restriction orders here. My lady, that's what I want to say about A and BBC. I've got 15 minutes left. I'll try and take the remaining points that I'd like to make reasonably quickly without taking the court to the relevant sections of the judgment, unless I absolutely have to, because that will slow us down. The first issue that the court indicated it would like to be addressed on is the scope of the common law power to make withholding orders. What I was going to do is take the court to Cuja as a helpful starting point, but the essential point that we'd like to make is that regarding that power and the principles that operate to govern its exercise, we respectfully say that the guidance provided by Mr. Justice Nicklin at first instance, that that power has to be exercised in accordance with the principles of open justice, is right. And we've characterised my Lordship's helpful summary, paragraphs 26 to 44 of his first instance judgment as helpful and pragmatic. What we've also done is draw the court's attention to the dicta in Abassi regarding the proper approach to the application of rights under the European Convention on Human Rights. The relevant paragraph for the court's note is paragraph 128 in the authorities bundle. That's volume 4, tab 35, page 1264. And what I wanted to say about this, in summary, was that on these bases, we respectfully say that the appropriate way to approach the making of any withholding order is to exercise the court's power to do so in accordance with the principles of open justice, as summarised by Mr. Justice Nicklin, while applying as and when rights...
Sorry, what are you reading?
The relevant section of Mr. Justice Nicklin's judgment, my Lord, is at tab 21, page 279 to 288.
Yes. You're reading from his judgment.
Yes.
Paragraph.
Well, the relevant section, the relevant principles, my Lord, are set out at paragraphs 26 to 44.
Right.
But my Lord will note that at paragraph 48, His Lordship noted that the general powers of the court to regulate its proceedings, for instance by making a withholding order, must be exercised consistently with principles of open justice. So it's that which the BBC, while remaining neutral on this application, would like to draw the court's attention to and express its agreement with respectfully. And as I say, my written submissions deal with most, if not all, of these points in greater detail, which should assist after the hearing. That's the first issue. The second issue that the court indicated it would like to be addressed on was reporting restriction orders, specifically the scope of any common law power to make such orders, and the rationale behind Section 11 of the Contempt of Court Act. Regarding the scope of any such common law power, we say, while remaining neutral on the appeal, that Mr. Justice Nicklin is right, there isn't one. And the clear statement of principle to that effect is obviously found in Lord Sumption's judgment in Cuja. And as my Lord, the Master of the Rolls, said earlier on, the statement set out at paragraphs 16 and 18 of His Lordship's judgment, we say, can only be read as having general application. That's just what they say, as Your Lordship put it earlier on. And again...
But I mean, that statement,
yes,
read boldly, seems to be inconsistent with the passages in Abassi, Wolverhampton, and possibly A versus the BBC, subject to what you've just said.
Yes, well...
a raft of material which seems to give the impression that the line is not a stark blue line drawn at the anonymity order, but it goes beyond that to a common law power to do whatever is necessary in the interests of justice within legal proceedings.
Yes.
And that if anywhere the line is drawn when somebody is seeking to bring a claim outside the legal proceedings to inhibit publication of material emanating from those legal proceedings. That's what's said.
Yes. My Lord, yes.
And it seems, speaking only for myself, that there's some merit in that, in the sense that there seems to me to be an inconsistency not directly tackled in Cuja, not directly tackled in the later cases, which don't say that Cuja is in any sense wrong, but don't address really the first 3 lines or 4 lines of paragraph 18 of Cuja. What do you say about that?
My Lord, yes, there does seem to be an inconsistency. Taking the authorities that Your Lordship has referred to backwards, I've addressed the court on A and BBC.
Yes.
Quite what I have to say about that.
I take the point, but A and BBC, whilst Mr. Ware places huge reliance on it, actually is only the precursor to a complete root and branch reform of the law of injunctions.
Yes.
And as we see in both Abassi and Wolverhampton, reporting restriction orders are expressly referred to.
Yes. The point I wanted to make about A and BBC, but didn't, of course, is that it was before the Supreme Court in Cuja as well, and was expressly referred to at various points as part of the court's consideration of the open justice principle. It's important that I make that point, and the references are set.
I mean, the problem from my point of view is that Lord Reed seems completely in Abassi to have understood that there is a complete seems to have laid down, if we can put it this way, that there is a complete difference between the common law principles that relate to open justice and to derogations from open justice in the context of proceedings, and a subsequent procedure where a contra mundum injunction pursuant to a cause of action is obtained, and he says reporting restriction orders fall into the former, not the latter category. So surely we're bound by that.
Well, my Lord, in relation to Wolverhampton, which was the second of the 3 authorities that Your Lordship mentioned, if I could direct the court to paragraph 10b of my written representations for later, my written submissions, where we say that we support and agree with Mr. Justice Nicklin's analysis of that judgment and its application, or the extent to which it applies here.
Right, but what about the passages in that judgment at paragraph 34?
Yes.
Reporting restrictions are prohibitions on the publication of information about court proceedings directed at the world at large. They're not injunctions in the same sense as the orders which are our primary concern. They're relevant as further examples of orders granted by courts restraining conduct by the world at large. Such orders may be made under common law powers or may have a statutory basis. Now that is directly contradictory. That sentence seems to me, anyway. I mean, I'm only, well, I'm only in the Court of Appeal, but it seems to me not to be readily intelligible alongside the words Lord Sumption used in the first part of paragraph 30.
Yes.
6 to 18.
Well, your Lordship does have what your Lordship described as a tour de force and a magisterial judgment provided by a judge with extensive experience in this area, and specifically at paragraph 52, where Mr. Justice Nicklin confronts that head on.
We're hearing an appeal from him, so we can say it's a tour de force, but we have to decide if it's right or wrong.
Yes, but the answer to that question, insofar as there is one, I would respectfully submit, lies in Mr. Justice.
You say he's right.
Exactly.
And Mr. Ware said he's obviously wrong.
Exactly. That's the position.
Okay, good. Well, that makes it easy for us.
Yes.
Mr. Brown, thank you.
Yes. May I proceed?
Of course.
My Lords, my Lady, yesterday, among the materials that were circulated was the judgment of the divisional courts in Socialist Worker ex parte Attorney General. That case is authority for the principle that the court has no common law power to make a reporting restriction order. The easiest way to show the court that, if there's any dispute about that fact, is to consider the decision of the Privy Council in Independent Publishing Company Limited and Attorney General of Trinidad and Tobago. I'm running out of time, so I won't take the court through it, but I think if I could just...
Which page is it at?
Yes, it's page 337 in the Authorities Bundle, my Lord. Volume 4, tab 6.
And what do you get out of this?
I get the Privy Council's analysis of that decision, my Lord, and its conclusion that it's authority for the principle that the court has no common law power to make a reporting restriction order. The reason why I'm bringing the court to this is because it was among the materials that were circulated yesterday, and I suspected the court.
Can I see where that is said in terms, please? Which paragraph?
Yes, the relevant paragraphs, my Lord, are, if I could ask the court to first turn to page 351.
This is a criminal case, right?
It's in the divisional court, my Lord.
Yeah, but criminal.
Yeah.
351.
Yes.
Yeah.
At page 351, one has the heading which identifies the issue under consideration.
Is there a power at common law
Yes.
to order the publication of a report of open court proceedings? Is that precisely the same question?
No, my Lord, I've more to say on that. I just wanted to start there, if I may.
Right.
Over the page on 352, paragraph 23, one has references to the Leveller case and to the Socialist Worker case, which we're discussing. Such was the position in the Leveller case itself. Such also had been in the position in Socialist Worker Printers and Publishers. Then, paragraph 24, 3 points should at once be noted about those two cases. First, that in neither of them was any order made directing the media not to publish the names of the witnesses who had been allowed to testify under pseudonyms. Secondly, that in both cases the Crown accepted that there would have been no power to make such an order. The report of the Crown's argument in the Socialist Worker case advanced. The Court's Counsel's acknowledgement that the trial judge had no power to make orders affecting the press or other media in their conduct outside the court. Then, my Lord, at paragraph 26 on page 353, the Lordships turn to consider consider the different category of case in which the present appeal lies, cases in which the court has no occasion to make any order directly affecting the conduct of the proceedings before it, but is concerned rather to guard against press publicity. The courts, in short, may wish to do precisely that which the Crown in the Socialist Worker case acknowledged that there is no power to do, to make orders affecting the press or other media in their conduct outside the court. Now, as the court knows well, because it forms part of the decision in Cuja, Independent Publishing Company Limited is itself also authority for the principle that the court has no common law power to make a reporting restriction order. I can take the court to the relevant sections of the judgment if that would be helpful.
Sorry?
I can take the court to the relevant sections of the judgment if that would be helpful.
Yes.
Um,
But that's Cuja 16 to 18.
This is Independent Publishing Company Limited, my lord.
Oh, right. Sorry.
Yes, still on that.
Yeah.
So it's paragraph 67,
67.
67, my lord, page 363, for the court's note. And relatedly, the court may wish to consider later paragraph 51, page 360, where the court identifies the new statutory power conferred by section 11 of the Contempt of Court Act 1981. As I said, the BBC is neutral on this appeal. We've sought to assist the court by addressing various of the points made by my learned friend in his updated skeleton argument. And I'll direct the court to that section of my written submissions. That's at paragraphs 9 to 11. The bundle reference for my lords and my lady is Open Court Bundle, tab 10, pages 81 to 84. And I won't dwell on that any further because I'm nearly out of time. I'll just try and assist the court by saying something. I'm very mindful of the court staff and people have stuff on, so I don't want to take too long. If I may just take 2 minutes for the final 2 points, my lord, and then
Of course.
in terms of the rationale behind Section 11 of the Contempt of Court Act 1981, which was another issue which the court sought assistance on, I don't think I need to say too much about that because the relevant section in Cuja, which is paragraph 14, establishes the necessary context, the ancillary nature of such orders, signalling that the power can only be exercised where the court has previously made a withholding order. That's paragraph 14 of Cuja, just to repeat that, page 771. That's obviously mirrored in the relevant section of the Law Commission consultation paper that the court circulated yesterday. For the note, it's paragraphs primarily A11 and also A111. And further paragraph on page 195, which may assist, is paragraph A112, 2 in brackets, 112, 2 in brackets. And there's further explanation which the court may find of assistance in Chapter 7 of Arledge, E. Dean Smith, which was circulated yesterday at 7-127. I don't understand there to be anything in those extracts which is necessarily in dispute. The core issue, as we've explored today, is the extent to which a withholding order needs to be made from the outset of the proceedings. The court has my submissions on that in my written submissions, so I won't labour that point. On the significance of names as an ingredient of the open justice principle, which was the third of the 4 points that the court highlighted, it might appreciate assistance on. The reasons why there's such an important feature and such an important dimension are set out by Mr. Justice Nicklin in paragraph 42 of his judgment. We respectfully agree with his lordship's analysis, which is obviously based on the Keim-Todner case and in Guardian News and Media Limited. Just to take head on a matter which I wondered if the court would like me to explore. It's the important statement of principle, my lord, of paragraph 39 of the authority that was circulated yesterday, which is JIH. And that's at paragraph 1329 of the additional authorities bundle. As I've already emphasised when deciding on questions of this sort.
So
Oh, I do
page.
apologise. Yeah, the page, I've given you the wrong page reference, my lord. It's 1338. I apologise. Paragraph 39.
Yeah.
As I've already emphasised, when deciding on questions of this sort, each case will turn on its own facts. Accordingly, it's not appropriate to suggest that there is some sort of general rule that anonymisation is more or indeed less likely to result in greater interference with free speech and maintaining public scrutiny of the courts than precluding the publication of more extensive information about the proceedings. And what we say about that is that that's not inconsistent with the statements of principle that are set out and summarised by His Lordship at first instance by reference to Keim Todner and Henry Guardian News and Media. The court will see that immediately. But I do highlight it because it does feature as an important statement of principle in JIH. And what we say about the approach which should be adopted when considering issues around names is set out in His Lordship's judgment at paragraphs 39, 43 and 44. So those are pages 283 to 288. We say that's the right approach. Modified as necessary to reflect the guidance from the Supreme Court in Abassi regarding the application of convention rights.
Sorry, which case were you on there?
Primarily, my lady, I was at the first instance judgment of Mr. Justice Nicklin.
I see.
And we were expressing our agreement with His Lordship's summary of how to approach matters involving names. But I did draw the court's attention to, as I did earlier, section in Abassi dealing with the application of convention rights, which, as your ladyship knows, places some nuance on the question of the balancing exercise, so-called. And the very last thing I'll briefly touch on, given that it was identified by the court yesterday, is the significance of previous disclosure of identifying information in court proceedings. We understand this to go to the principle identified at first instance, at paragraph 63, which my learned friend brought the court to earlier on. This is a tab 21, page 292, that an essential precondition to making of a reporting restriction order under section 11 of the Contempt of Court Act 1981 is that their name must have been withheld throughout the proceedings. My submissions on that are set out in my written submissions, so I won't repeat them here. If I can assist further on that, I of course will. Yesterday the court circulated an authority and various extracts from 2 textbooks which dealt with the quality of confidence that information which form part of the court process but which hadn't been deployed in open court might enjoy. That's chapter, it's the breach of confidence chapter from Moorman Speaker. This is at page 157 of the additional authorities bundle. I won't take the court to the relevant extracts. I'll simply highlight them. They're paragraphs 4.96, 4.97, and 4.100. And what we say is that those authorities, those principles, and the authorities cited within them, including Banerjee, which was also circulated yesterday, must be supportive of His Lordship's general position at first instance regarding the necessity of a withholding order being made from the outset of proceedings. And insofar as there's any dispute about that, of course, the court has the decision of the decision in Press Association and Cambridge Crown Court, which again we discuss in our written submissions.
Very good.
My lords, my lady, I've been quite rushed, but I hope that has been of assistance, and I hope my written representations are of assistance too.
Very helpful, Mr. Brown. Thank you. We'll adjourn now, resume at 10:30 in the morning.
All right, so people.